Justice Joseph Kurian will be joining us shortly. Winning and losing to understanding and resolution. It empowers parties to engage in dialogue, identify their real interest, and arrive at the outcome that is not imposed but mutually agreed upon. In doing so, mediation preserves relationships, saves time and cost, and reduces emotional burden of prolonged disputes. Most important, mediation places people at the center of justice. It recognizes that disputes are not just a legal problem, but a human conflict requiring empathy, communication, and understanding. As mediation gains increasing judicial and legislative support, it is clear that it is no longer an alternative, it is an essential pillar of effective and accessible justice. In this sense, mediation truly represents the heart of modern dispute resolution. Now, not taking much of your time, it's my honor to introduce our first speaker, Honorable Justice H.M. Dilip Nawaz, Judge, Supreme Court of India, I'm so sorry, sir, Supreme Court of Sri Lanka. I beg an apology, Your Lordship. I beg an apology, Your Lordship. I'm sorry, Lordship. His presence today adds a valuable international perspective to this session on mediation, particularly in understanding how mediation contemplates constitutional values, enhances judicial efficiency, and strengthens public trust in justice delivery system. Over to you, sir. And I beg an apology, sir, please.
Right, anyway, thank you very much. The moderator, Rina Pandey, right? Yeah. 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 My brother, His Lordship, Justice Pankaj Mittal, the distinguished members of the audience, great lawyers, and of course the President. I have the privilege of having the President here, and of course my good friend Guru sitting at the back after having delivered possibly a thundering oration there, I believe, right, and all the ladies. Thank you very much. And then so we have this theme of mediation at the heart of modern dispute resolution. Now, when I was seated there, listening to a question posed to me by that attorney at law, that lawyer, who is also a mediator, she posed a pertinent question to me. The question was whether Sri Lanka has a statutory underpinnings of mediation. Well, there is a slew of legislation, host of legislation, which embodies mediation in a number of statutes. Community mediation has been at the forefront of Sri Lanka's legal system. There has been, just like you have the panchayat system, you had that. I would see all of them happening in the Indian films, which I love watching. After a hard day's work in the Supreme Court, I go back and I watch only Indian films, I must tell you, right? Because I have all the Indian channels on my TV. So when I watch them, that old panchayats where the dispute between the bridegroom and the bride and all that, right? So we have the same system which is replicated in that Mediation Act specifically. So mediators are appointed. They deal with this peace mediation. It is really peace mediation. When I looked at the Mediation Act of 2023 of India, I find the echoes of such a possibility even under your Mediation Act 2023. I have been going through it, and I feel like writing an article when I go back, and I will send it to the President for circulation on the Mediation Act of 2023. But anyway, I will not be talking on that before you, because you know that act very well. So the question you posed about this litigation mediation, which I saw in full bloom at the Delhi High Court when I was there last month rather, and I was taken to the mediation center and the arbitration center. At the mediation center, there was an advocate, the president of who was explaining to us as to how in the year 2000 or 2003 this came in, and then today it's some of you are the best mediators in that establishment. I was also talking to two claimants who were seated. One claimant, it was a land dispute. One claimant was seated in one corner, another claimant was seated in another corner. I spoke to both of them because they didn't know that they were speaking to a judge. I spoke to both of them, and the dispute had arisen about 10 years ago. It is still ongoing. So mediation, but I see the court-annexed mediation, the concept of court-annexed mediation and the voluntary mediation concepts quite attractive. And Sri Lanka, if I may give you a little landscape about it, we passed a bill, or rather, we enacted a bill. We have what is called a pre-enactment review, not a post-enactment review. Now, unlike India, you have a post-enactment review. Any law can be repealed or even declared invalid. But in Sri Lanka, when a bill is published, it is brought and challenged. A novel system, right? We were posed that question by Justice Maheshwari himself at a bilateral session. Why do you not have? It is the politicians who make all this. It existed, post-enactment review existed in Sri Lanka until 1972. Afterwards, when the Privy Council said, certain laws have to be declared invalid, a new constitution came in, and then they took it away, because Privy Council said that this law must be declared invalid. So when this bill, very revolutionary, modeled on the Indian lines, came up in the Supreme Court for review, judicial review, well, it was challenged by the Bar. The Bar Council challenged it as unconstitutional. The Bar Council mounted a challenge and stated that this law cannot be passed because it takes away, yes. But Bar Council opposed it on the basis that it will take away the lawyers from suit. Right? In other words, you are seeking to deprive the legal community of its income. This was the opposition. But we declared the bill constitutional and told Parliament to pass it. But the lawyers again agitated with the executive, and the law was killed. And the Supreme Court called it constitutional, declared it constitutional, but the Parliament has not passed it. So we don't have court-annexed mediation. We have voluntary mediation, but if a suit is brought in regard to an arbitral action, or if the commercial court can refer parties to mediation, that is there. The commercial court can refer them to, but Supreme Court can't refer them, District Court can't refer them, so that's the pity that we have at the moment. Then, as that's so much for mediation in Sri Lanka, but I wanted to touch on some normal topics that have engaged my attention, something which I have engaged with. How certain relevant topics are attracting the attention of mediation practitioners. I spoke about it some time ago, if the President can recall, in Visakhapatnam. Later on, I went and sort of rephrased the whole thing, and then I looked at it, how AI is trending in the future, in the future mediation. Now, recently I read an Indian judgment where a lawyer challenged a summons issued on him when he was asked to come before the corruption court for some legal advice tendered to a client, and then corruption bureau had told him to come. The judgment reads, kill all the lawyers. Indian judges, I must say that I have a lot of fascination for the way in which they write. Kill the lawyers. So will mediation kill the lawyers? That's the next question. With the advent of AI, artificial intelligence, storming, but I would say this. Before I became a judge, about 14 years ago, I was heavily involved in arbitration. I appeared for the state of Sri Lanka in a number of arbitrations. One arbitration was about a construction contract. The construction contract involved a number of documents like this, and I had spent sleepless nights poring over those documents, trying to ferret out the relevant documents, but I wish I had AI in those days. Had I had AI, it would have been quite useful to me, because then AI would have helped us a great deal in identifying the relevant documents. Mr. Guru and all of them have promised to come to Sri Lanka. If you come to Sri Lanka, you must go down this particular highway over which this arbitration centered. It's called the Southern Expressway. It takes you from the capital, Colombo, to Galle. She was speaking about her stay in Galle, right? You would have gone down the whole way. But this particular Southern Expressway had this greatest arbitration going on for days on end. Going on for days on end. Welcome to my brother Justice Korean Joseph. So now the Japanese who were the building contractors sued Sri Lanka. So in that we asked for discovery. They were dumping us, as Japanese are. They were dumping us with a lot of documents. We were finding it difficult to conceive the relevant documents. So the point that I'm trying to make is this. There are cases that are being referred to mediation now, IP cases. There are cases that are being referred in a number of, a variety of cases to mediation. In such a situation, artificial intelligence should be able to help us in sieving out the relevant documents from the irrelevant documents and help us a great deal in the disposition of these cases. That is one point that I wanted to say, the contract identification. But another point that I would like to make is this. Now, many a writer, even from India, I saw an article written in the arbitration journal put out by the Delhi Arbitration Center. They gave us a comment. In that article, one writer comments that AI can help a great deal in IP-related mediation. IP-related mediation. Maybe the mediation cases that you are dealing with may not be relevant to this, but I'm looking at the future. Now, I take a slightly different view. You may find artificial intelligence relevant and quite useful, but even in IP-related cases, it all depends on the nature of the dispute that parties bring before you. Only when the nature is ascertained by you, or rather, it will be relevant to see how AI can help you out. Now, if you take a patent infringement, which is today in many countries in Europe and other places, patent infringement is more of a case for commercial mediation these days. Parties come. So that is one area in which I take the view AI cannot be all that helpful, because what you are trying to do there in a patent infringement is whether one product is infringing upon another patented product. So in such a situation, I take this view that AI will be more suited in those cases, because the moment you feed AI with the specification of the first and the specification of the second, and how process has led to it, AI will be able to tell you, distinguish one from the other, and tell you whether there is an infringement or not, because it's more based on facts. So when facts are involved, when engineering or the technical details are in dispute, well, AI will be able to give you some kind of assistance and will help you. But if you take trademark infringement cases, I hope that I'm raising these issues so that you can mull over it. Their AI may not be all that helpful. Why do I say that? It is because in trademark infringement, what we try to do is whether there is consumer confusion. In other words, two products, I remember doing a trademark infringement case long time ago when I was a lawyer, and in that case, my company for which I appeared did a consumer survey whether they were confused in the supermarkets when they saw the two. So this examination of keeping one product against the other and in indulging in a comparative comparison to see whether the two products are confusing similar products or confusingly similar, that is something AI will be hard put to deal with, in my view. So it all depends on how the dispute is all about. Now, I'm raising this issue before you because I read this article of this academician in the recent journal where he said across the board, IP cases can all be dealt with by a mediator with the use of AI. And I also wanted to raise this point. Now, just this morning I read in the internet, in the US, 75 cases have been filed against US companies, and now AI companies, for copyright infringement. 75 cases. So now cases are proliferating. So in copyright infringement, what happens is, you know the originality theory. Whether one article, your expression has been copied from another. So in the UK, India, and Sri Lanka, we have a lower threshold, right? We just see whether the expression, the article that I have composed is original, right? My industry and all that. But I saw I have read about the Japanese threshold. It's quite high. It's quite high. In other words, even expressions, if somebody has expressed it in the past, even that dichotomy between expression and creation is also very thin in Japan. So now you can see in one region there are various forms of originality advanced by different legal systems. So if you use AI in future mediation to ascertain the concept of originality, AI systems developed by United States or European states will not be able to give an unbiased opinion about the originality developed by the Japanese courts. So you have this bias infecting the decision-making powers of the AI. So I raise these questions before you so that AI will be thought of as one area which may be useful in certain cases, which may not be useful in other type of cases. So having advanced that point, if I may summarize what I have said, in IP cases, patents based on technical matters, AI will be useful. In copyright, it may not be all that useful. In trademark, again, I'll say human sensitivity, perceptions, cultural diversity all play into it. So AI will not be all that be helpful. So now, the point that I'm trying to say is that when the Indian judgment, which I read recently, when Arvind Datta was summoned, and then when the judge started his judgment with this quotation, "Kill all the lawyers," I do not think that AI will kill all the lawyers, right? AI will certainly help us, but decision making is going to be our domain. Unless they call it the human in the loop. Unless there's a human in the loop, I do not know this trending influence of AI will overtake us in mediation. There is also another point that I may tell you. Now, Singapore, I must say that Singapore Convention, Sri Lanka became a party, which is very unfortunate that we couldn't pass this legislation last year, even though the Supreme Court passed it. That's another point that I wanted to say. And so now this Singapore in WIPO mediation center, they had at Maxwell Chamber in the discussion where Mr. Guru was one of the members, Maxwell's chamber was spoken about. That was one chamber which I used to haunt those days when I was appearing for Sri Lanka in a number of arbitrations, right? I wish I had not become a lawyer, or rather a judge, and I wish I remained a lawyer, right? Distance now enchants you now, right? Justice Kurian Joseph will tell us more about the retirement, how the arbitration landscape is attracted to him, or mediation landscape. I've read a lot about your work. The other point that I am trying to say to you is in Maxwell Chamber, you have the mediation center. Now, recently, they came out with a case. Two brothers came before the WIPO Mediation Center for resolution of an IP case. It was a mediation. The mediator was speaking to the two brothers. It was not so much about the IP violation. It was really who should take control of the company. So the mediator listened to the tale of woe, both brothers were listened to, and finally the mediator said, why don't you sell out your share to the other brother? The other brother must be compensated handsomely, and with that, everything ended so well, and one brother took control. So even though it was brought in the form of an IP violation, what that mediator was doing was a non-IP case. This I read this interesting story recently. If you go to that page of WIPO Mediation Center page, you will hear these stories. The point that I'm trying to tell you is, it is a mediator with an empathy who can understand this. So let me end with this point that mediation has come to stay, and let's promote peace mediation. Let's promote mediation in an effective manner, and then we will reduce the backlog, and we won't have to spend long hours poring over briefs in the Supreme Court or any other court. Right. Thank you very much.
Thank you, Your Lordship, for enriching this session with his wisdom and experience. Before beginning our next speaker, may I ask Sanjeev Kumar Kaushik, advocate, to present a bouquet to Justice Kurian Joseph, former Judge, Supreme Court of India. It's a great honor and privilege to have with us just our distinguished speaker, Honorable Justice Kurian Joseph, former Judge, Supreme Court of India.
That I'll save the time because I made a mistake. I was very active, had a very sumptuous breakfast, so I just went for a postprandial sleep. And I read my session was at 11 o'clock. I don't know, it's some confusion. And I'm glad. I'm extremely privileged to share a session and to be on the dais with my beloved brother, Pankaj Mittal. And the first time we are meeting the Justice Dilip Nawaz and my dear young friends, including Professor Sebastian, who was a long-term principal, who have so many of his disciples as judges in the various high courts, and including our Guru, the one senior advocate I can see here. Sir, Guru, in the real meaning of Guru, is actually the one who is able to remove the darkness in the minds of the disciples, actually. Guru, yes. That's the meaning. One who is in a position. There's a lot of difference between teacher and the Guru. Teacher teaches, but the Guru actually forms. He removes the, yes, gives lights and removes darkness in the minds of disciples. Only difference is teacher has students, Guru should have disciples. So, no Guru will have a student, Guru will have only disciple. So we are on mediation, and when I came, I heard my brother speaking about this artificial intelligence. The first thing that we should be very careful in mediation is not to be artificial. Mediation, if you are simply normal, genuine, simple, straight, honest, and transparent, half of the things, because you happen to mediate because people are not simple, straight, honest, prudent, and transparent. So it's where, you have to navigate or guide people to be all this, so that, like the brothers. Why did the brothers fight for a thing? When they started, they were real brothers. They had a good relationship and they had no problem, had a good business. When the business thrived, then the equations changed. Normally in the South, we say, when they were bachelors, there was no problem, but they were married, the whole problem started. My apologies for my beloved Babis. In a way, it is true, because, these people who come to the family were not in the family. Only these people who are in the family, when they are together, they have very good equation. But we have people joining the family, the equations may be different unless you are able to gauge the vibe and then, take it properly. Whom to please and where to please, how to please and why to please. All these four things, if you are able to understand, probably you'll be a very good mediator in family businesses also. And we see, as Brother Mittal also would agree, that almost 75% of the corporate disputes, the underlying problem is a family ego dispute. There's nothing else. It's a family ego dispute. 75%. 25%, of course, they have their mercantile, what you call, aspirational differences. Because somebody thinks, why should I share my profit if I can make the profit myself? This becomes the avarice. When we were very, very comfortably going as partners, you did not have any problem. But when partner starts to think that, why should I make all the labor and then share my profit? That fellow is, except putting his money or coming in his formals and then doing nothing, and I spend my money also. See, this you knew when you started, no? What is the worth of a partner you are taking and what is the contribution we expect a partner to take. So your frustration is not something which you did not know earlier. You knew that this is the worth and this is what he is going to contribute. So when you start a partnership, you knew that this is actually the potential, these are the potentials also. Having said that, I just would like to come to the practicalities or practical aspects as to how to make this mediation effective and how to encourage mediation. I don't know, Brother Dilip, you have a constitutional bar in practice after you demit office in the Supreme Court?
Yes. Unless the president gives permission to you.
Oh, here nobody can give the permission. That's our problem. Your roti chawal is lost, but... no, India also arbitrator. We see, me so comfortable and so young because I'm very busy in arbitration and mediation. That keeps me young. Can you believe I'm retired now, 8 years now? This is my 8th year. Yeah, that's right. What keeps me young? I'm still in Delhi. I'm still very active in the profession, not as a lawyer, not as a judge, but as an arbitrator, as a mediator, as a consultant. So all these three formats, and brothers like Brother Mittal, when he finds a difficult case, he say, all right, you go on for mediation to... No, in the real sense, see, the very beginning of actually encouraging mediation, according to me, are 2-3 things. One, let me say from the judge's angle. From the judge's angle, if we were thinking in the morning about the true judge, honest judge, the popular judge, activist judge, etc., conscientious judge. So actually, for a judge, I didn't get time. The oath of a judge is in Schedule 3. Without fear, favor, affection, ill will. If these 4 things go, he'll be a very good judge. So let us have only qualifying, not have quality of judges, not qualifying adjectives for the judges. That's the best thing we should. So for judges, the best thing, a training of a judge to be a good mediator is to know which case is to mediate. And if you really want to encourage mediation, what I used to do, both in the High Court as a judge and as a Chief Justice in another High Court and in the Supreme Court also, almost 19 years of my judicial career. What I used to do, lawyers will be initially unwilling. Now they are started to be willing. The clients are not willing. They always say, no, we don't want these things also. Why to waste our time? We want a judgment. We have a lot of faith in judiciary. We want a judgment. Who has no faith in judiciary? Everybody has a faith in judiciary. It is actually a judicial act, or it's a part of a judicial innovation. And this is not less prestigious a thing that you get in mediation. This is something people should know. So to me, I used to call people those days, call people into court, and many of you are aware, people used to be called in court and told them, friends, this is your case. You want a judgment after paying so much of money to your lawyers and spending time, or you want a solution. If you get a judgment, one side is likely to be happy, the other side is to be happy. A judgment becomes bad when both sides, we try to make both sides happy. Then it's not a good judgment. Only one side can be happy in a judgment. But in a mediation, both sides can be happy. This is all difference. So if you want a solution permanent, you have a temporary solution, a judgment, you have a permanent solution. So if a judge is in a position to call people to the court and say, this is your problem, it can be addressed in two ways. It can be addressed by your lawyers and the judgment can be delivered. But to me, I feel this is not going to solve your problem. You may get a judgment, you may get a verdict by way of understanding what it is and what it is not. But if you really want to mend your ways and end a problem, probably mending the ways and ending the problem permanently, only mediation is possible. So if the judge says, we'll give a try because the judge said so, we'll give a try. The advantage of the judge making such an observation is two. That's the second aspect. The lawyers generally may not be that interested in sending people to mediation. I don't know, Sri Lanka, what is the practice? Here in Delhi, or rather in the north, we have a practice, that the lawyers are paid per appearance. So, whereas in south, when I come from the south side, we don't get appearance fee. 20 years of my practice, I never had appearance fee. I only got a fee for a case. That's one-time payment. It's a one-time settlement, nothing else. I wish I were a lawyer here, because I got designated at the age of 42. Had I spent quite a few years here in Delhi, probably I may not have become a judge, as Brother Dilip said. Anyway, if the lawyers will also get an encouragement, then the lawyers cannot go back. When the judge says from the court that it's a case for mediation, the lawyers should cooperate. Here in mediation, Brother Dilip, for your information, generally we mediators, after maybe 1 or 2 sessions, we get the permission from the lawyers and speak to the parties straight, and just to understand the problem, because no client will ever speak the truth in the presence of the lawyer. He will only give the version of the truth or version of the fact. So therefore, we always get the permission of the lawyers and ask them, please, if you don't mind, leave the parties to the mediator and let the mediator make an attempt to see. Before the mediator, in caucus sessions, they will tell the truth. They will tell the truth because they have a confidence in the mediator. The moment the greatest thing that the mediator should have, that the neutrality, which we are speaking in the morning, the neutrality of the mediator is what the clients always should have the confidence. The moment you get that confidence that you are neutral and you will actually navigate, instead of your second step only is negotiation. Because any mediation is a negotiated settlement. The simplest definition is a negotiated settlement. But instead of negotiation, you will start navigating, then you will get the confidence. The moment you start, instead of before navigation, if you start negotiation, you will not get the confidence for the parties. So the lawyers, it should be told by the judges according to the court that this does not absolve you from paying the fee to the lawyers. Then they will be very happy. Then the lawyers will cooperate. Otherwise, I'm telling you very honestly and bluntly, because Sri Lanka is part of our own system, so Brother Dilip also will be happy to listen to this. I had a wonderful 2 settlements in 2 cases after huge trouble. One of the parties said, sir, I'll sign it tomorrow. Let me talk to my lawyer. I said, no, I'll talk to the lawyer. No, sir, I had to talk to the lawyer. And I put the story short. The fellow came back and said, sir, sorry, I may not be in a position to agree. Don't ask me any further. So what can I do? So the lawyer normally doesn't permit, because nobody would like to kill a golden thing. So that is one problem. So instead of the clients should be settled with the fee of the lawyer before the matter goes for mediation, that this will work. Otherwise, this will not work, I am telling you. Because the mediator has to see the legitimacy. It's not that the party will have to go and seek the legal opinion. No. Because it is the duty of the mediator to see that this is legitimate. Because no mediation can end up in a settlement without the mediator certifying that this mediation settlement is a legitimate settlement. It's lawful and legitimate, and so it is actually the mediator's role also. So therefore, I'm saying we have to please the lawyers if we want to really actually encourage mediation, and the lawyer should be, the client should, the people should be, litigant should be told by the court and the mediator that this does not absolve you from paying your fee to the church. So whenever a case goes for mediation, please lawyers, you settle the fee. Even if you settle or not, this will be my fee. You have to pay the fee. But as mediator, I used to take care of this part, because towards the end of mediation, I used to call the lawyers also and get them also involved and say that the people, the litigants, I used to tell them my fee was different. I never take a fee for mediation. I always give to charities and ask the people to give to charities. I've not taken a single rupee in my whole life, 7 years of my mediation. Even when the fee came to 1 crore in a mediation, I did not take a single rupee. I told them, you pay to charities, because I have my own other fields of income. That is arbitration. I have my arbitration income. So this is my dedicated, passionate service. Actually, the day one of my entry into this law as a lawyer and as a judge, my court in Kerala was known as a love corner. Snehamula, to say in Malayalam, love corner, because I used to call parties and ask them to sit in one corner of my chamber, the other party in the other corner, the other party in my secretary's chamber. And I used to leave actually maybe around 9 o'clock also in the evening after talking to parties also. Then I used to train lawyers also to send them also. So in the simplest terms, I'm saying we need to encourage this mediation by the involvement of the judiciary. Without the judiciary involving, no mediation will ever be successful. Without the lawyers cooperating, it will never be successful. And third thing I just wanted to say as far as courts are concerned, particularly Mithal in the Supreme Court also, even if you happen to dismiss an SLP, if the lawyers will start the last argument, my Lord, kindly issue notice that we can explore the possibility of a mediation. So in which case I would say you don't have to issue notice, this is my suggestion, you don't have to issue notice, call the parties to Delhi for mediation. You can say, all right, we give you liberty to the party to go back to the High Court and explore the possibility of mediation. Leave them to their respective High Court, because the mediation at the respective High Court could be a better process rather than calling the parties for an expensive, unless of course the parties can afford to and the parties should afford to. These are two things, can afford to and should afford to. Because there are certain parties who will not stop their fight unless they spend their dedicated money and time. So they have some dedicated time and money for litigation. So we must help them to spend it also. That I always. Second thing I wanted to say, in the courts, in the process of hearing also, when the judge comes to a feeling that instead of my giving a judgment in a case, probably it will better serve my Lord, ended with the word peace. It will end, because any settlement actually the result is peace. The result is peace. Any judgment need not necessarily end up in peace. So if you really want peace, actually, the judge should be in a position to discern. Maybe it's a case before me filing this bill should give a chance to the parties to judges also can do it. We can also involve senior lawyers. In the Supreme Court, many senior lawyers, including Guru, so many, almost all the senior lawyers I knew, I used, because they should also dedicate some time for some. Thank you. They can also do it, because when those Guru Krishna Kumar has done my mediation. It has a elated status for the parties. Mugul Dhoti has done my mediation. It goes like that. Now I sent two names because there are many names. So almost all the renowned seniors in the Supreme Court I used to encourage, because that actually gives a different ambience for the mediation process and also for the parties also to say that we have settled this case before that judge, that lawyer, etc., etc. That's also so, because these are all things will go a long way to actually satisfy the ego, which is actually the underlying problem for any dispute. Then the strategic success in mediation, since you're all in mediation, one, understand that there is a dispute. If there is no dispute, there is no question of mediation. My Lord Mittal would always say, no, if there is no dispute, then there is no point in going for mediation. It only is a dispute, because if it is a fight for a question of law, because there are parties, sir, my problem is I want a judgment, not anything else. I want a judgment. Let the court say. If somebody takes such a position, second thing I have seen certain clients say, sir, it is not yet ripe. You can eat a fruit only when it is ripe. This fellow will become ripe only after 5 more years of fight. That also is some sort of an attitude. He is too premature according to them, because they have not yet seen the brunt of continuing litigation. So let some more peace be lost from their family, then only they will end. So in actually, one, there is a dispute. Secondly, what is actually the core of the dispute? This is where the mediator's role, this is my third position, judge, lawyer, then the mediator. The mediator should be in a position to just talking to them in group and in separately. If you conduct 2-3 sessions, you will come to know what is the underlying problem. I'll tell you, I will not cite the parties, but I can tell you one very interesting case. There are 2 sisters fighting. A huge property they have, unearned property, because their father only earned it for them. They have not spent even 1 drop of sweat for that. Hard-earned money nobody would spend for any litigation. You can rest assured. This all 100%. All these disputes are there because they have never toiled for earning this asset. So these sisters, after some time I understood, these people are not interested in what they are getting, each one. What the other is getting, or other is not getting. These are the 2 things. So I understood the best way to tackle is not to tell them what you get, but to tell them what the other side does not get and other side other side will not get. Actually, it succeeded, because instead of understanding what the share, because I started, it's a negotiated settlement. Because parties asked me to negotiate. From the mediator, I went and crossed the limit of being a neutral observer, etc., etc. Sometimes, there is a borderline limit. To some stage, you will have to cross that stage and, assist the parties for you may not be assistive, but you may be a bit of an evaluative. So I just went further and said, no, this is, but this fellow I find is not he's not actually interested in looking at what she gets. She's interested in what is she getting. So I showed the other way first, what she is getting. Oh, then she was very happy. Then actually what the fellow who was disputing got actually little less, but doesn't matter. But I could make her understand that this is no problem, this is less valuable than what we get, and this was satisfying the ego, because you will have to understand in these high-stake disputes probably it's not actually the what you call the equal division, is actually equal satisfaction, or rather the satisfaction of the ego of a person more in dispute will be the solution for a mediated settlement. And probably I would end also, there's time for us to end also. In mediation, there should be a passion for a mediator. Unless the mediator is passionate, unless the judge is passionate. You can see Brother Mittal always smiling. In court also you have seen a shining face. That itself gives a lot of satisfaction. So to look at the Brother Dilip, even he will not say, we can't say he is a judge, just normal human beings. There's nothing normal, there is nothing wrong in being normal and human, even when you are a judge or when you are a mediator. So just to have the peace settled once the things are finished also. And the innovation in mediation, this is one sentence I wanted to say finally. You may not be, you should be in a position to understand that the only case that is referred may not be the issue. Actually, there will be so many connected, related or associated issues. Nothing, according to me, nothing stands in the way of you as a mediator in getting those issues also put into the kitty and finding an absolute solution. Otherwise, your solution to a referred matter, you may be able to mediate and settle. But that will not necessarily give
a solution to the problems in the family or problems in the corporate entity. You need to identify the related disputes also or associated disputes also, so that there is no chance for a litigation between the parties any further. So that's the last sentence we always said, the parties agree that they shall not rake up any new dispute in respect of this, in respect of the subject matter. And sometimes even if there is going to be a difference of opinion, they will first seek the opinion of the mediator. You'll go first the mediator before going to the court. Those are all innovative measures you can try always. And I tell you, it will be, Brother Dilip would pardon me when I say it will be a little dangerous if you use artificial intelligence in mediation, because mediation is all innovation. Artificial intelligence is what is only fed. What is fed into it, it gives back. Nothing else. There's no innovation. There is a stage at which, the intelligence artificial cannot go beyond. It is not beyond. That is what is called, let me stop, the sixth sense of a judge or a mediator and third eye of a judge or a mediator. If you have this third eye and the sixth sense, there's nothing which you cannot settle, be it mother said patent dispute, be it a financial dispute, be it otherwise a corporate dispute, be it any other dispute. In dispute, if the mediator has this third eye to see into and sixth sense to go beyond, you will be a very successful mediator. Thank you very much. And once again, deep apologies for being delayed.
Thank you, Your Lordship, for your insightful address and for affirming the transformative role of mediation in delivering human and enduring justice. Now may I respectfully request our Honorable Justice Pankaj Mittal, Judge Supreme Court of India, to kindly deliver the judgment.
Namaste. A very good morning to all present. My brother from Sri Lanka, Justice Dilip Nawaz, my respected brother Justice Kurian Joseph, learned members of the bar, judicial officers present, academicians, distinguished guests, ladies and gentlemen. The topic for this session, mediation at the heart of modern dispute resolution. It is very close to my heart. Initially, when mediation was started in Allahabad, it was pioneered by Justice Kardju and Shri Ram Panchu, senior advocate from Chennai, had come to train the mediators. I was not very comfortable. I thought we are leaving the work of adjudication to the mediators. But slowly, with experience, my opinion changed. And I came to realize that mediation is not an alternative dispute resolution system. Rather, it is a more appropriate dispute resolution system. Two of my colleagues have spoken before you on their basis of their experience, and I have very little to add, but still, I will complete the formalities. See, today what is happening, the courts today face rising caseloads, increasingly complex disputes, and heightened expectations from litigations. While adjudication remains the cornerstone of the rule of law, it is no longer sufficient by itself to meet every dimension of modern justice. Disputes today are rarely confined to legal rights. They involve continuing relationship, emotional investment, commercial realities, and social consequences. A judgment may bring legal closure. It does not always bring resolution. The resolution of dispute is not always best achieved through authoritative determination alone. In many cases, justice is better served when parties arrive at solutions. through structured dialogue, with the law acting as a facilitator than an enforcer. See, what happens, it is always due to the break in the dialogue that disputes arises, and there may be various factors. And in this regard, I am reminded of a couplet of Justice Basim Barelvi, where he says, कौन सी बात कहाँ कैसे कही जाती है, कौन सी बात कहाँ कैसे कही जाती है, ये सलीका हो तो हर बात सुनी जाती है. And it is for this breakdown of dialogue that litigants engage lawyers as their representatives. But today we find even lawyers, they break the dialogue. The problem arises. Anyway, this conversation gains added significance as India reflects on 75 years of Supreme Court. Institutional maturity invites introspection. It calls upon us to examine not only what courts have achieved, but how justice system must adapt to remain effective, credible, and human in the years ahead. Mediation must not be examined as an alternative in name, but as an appropriate and central component of modern dispute resolution. This is the premise on which this session proceeds. Across jurisdictions, justice system today face a shared challenge. Courts are overburdened, litigation is expensive and time consuming, the emotional and the financial cost of disputes is often disproportionate to the issues involved. For many litigation, justice feels distant and emotional draining. While adjudication remains indispensable, particularly for constitutional questions, criminal liability, and issues involving public law, it cannot be the sole answer to every dispute. A system that relies exclusively on adversarial determination risks reducing justice to binary outcome. One party succeeds and the other fails. However, disputes in real life are rarely so simple. They involve continuing relationship between families, business partners, neighbors, institutions, and even nations. In such contexts, a judgment may end a case, but it does not necessarily end the conflict. Mediation responds to this reality. It does not seek to replace adjudication, it complements it. Rather, it supplements by addressing dimensions of conflict that courts by design are not equipped to resolve. See, in a country like India, where we have a population of 140 crores, so much, now everyone, I just illustrate, every citizen is creating dirt throughout the country. And now if the government employs 10,000, 1 lakh, 2 lakh sweepers to clean the cities, it may not be possible. The dirt which is being created by all the citizens cannot be cleaned by these 10,000 lakhs of people. Same way, if the litigation is being imposed upon the citizens, now what we count is the ratio of the citizens and the judges. We take the number as 140 crores. But in fact, there are so many other legal entities. There are companies, there are NGOs, there are societies, there are institutions. If we take all together, the number will be double of the citizens. So we have to count the ratio of the judges on that, which we are not doing. This is one mistake we are committing. And even if we employ the services of maximum judges, we won't be able to resolve these disputes. So mediation becomes necessary. In Allahabad, I have seen the strength of 160 judges. We don't have even the necessary infrastructure. We are working with 100, 110 judges. But that is also, it is not hastening the litigation. Rather, it is being delayed more. So we have to avoid the disputes. And the one system is that we can take these disputes, whatever little disputes are there, to the mediation before coming to the courts. In doing so, mediation reflects a shift in judicial philosophy from authority to facilitation, from command to consciousness. Traditionally, the authority of courts has flowed from their power to decide. In mediation, legitimacy flows from the consent of the parties. This does not weaken the justice system, it humanizes it. In the sense, mediation is not an alternative of justice, it is an extension of it. It allows the justice system to respond not only to the disputes as legal problems, but in conflict as a human reality. Now this mediation is not new to India. For India, mediation is not a borrowed idea. It is deep-rooted in our society and cultural traditions and wisdoms. Kautilya's Arthashastra advises that stability is best achieved through agreement and not force. Kautilya's fourfold strategy of Sam, that is conciliation, Dan, offer, Bhed, division, and Danda, force, teaches that dialogue and persuasion must always precede coercion. The ideal leader, this is what Kautilya says, the ideal leader, he said, is one who wins peace without war. Wins peace without war. We all know, after war, the winner is again a one-legged person. Whosoever wins, we have the Mahabharata as an example. Pandavas may have won, but they were shattered. Now, Ramayana offers a powerful image of mediation when Lord Ram sends Angad to the Darbar of Ravan. He carried the final message of peace and opportunity for reconciliation before the war. And if I go back to my younger days, when I used to go for Ram Leela in Allahabad, there was a patent dialogue regarding this episode of Angad visiting the Ravan's Darbar. So Ravan is saying, "Hey Vanar, tu kaun hai, kya hai tera naam?" Brother, please excuse me, you may not be, because it doesn't have the titles. You may be watching Hindi Bollywood movies, but with English titles. Yeah. Sri Lanka. So Ravan is saying, "Hey Vanar, tu kaun hai? Kya hai tera naam? Tu kyun aaya hai kya tera kaam?" Now the Angad replies, "Hey Ravan, मैं अंगद, वानर राज बाली का पुत्र, श्री राम का दूत हूँ, लाया शांति का संदेश हूँ। यदि सीता माता को लौटाकर संधि तू अपनाए, सुख शांति बरसेगी, प्रलय की छाया टल जाएगी। किंतु हट न छोड़े, राम का संदेश ठुकराए, प्रलय आएगी, धन लाभ स्वपन बन जाएगा." And this happened. The truce was not agreed upon, and ultimately Ravan had to be killed. Now there is another instance of mediation, and that is from Mahabharata itself. Lord Krishna himself goes to the Kauravas. And this has been very succinctly said by Dinkar, Ramdhari Singh Dinkar, in one of his poems, Rashim Rathi. When Krishna goes there, he says, "मैत्री की राह बताने को, सबको शुभ मार्ग पर लाने को, दुर्योधन को समझाने को, भीषण विध्वंस बचाने को, भगवान हस्तिनापुर आए, पांडव का संदेश लाए। दो न्याय अगर तो आधा दो, दो न्याय अगर तो आधा दो, इसमें भी यदि वादा हो, तो दे दो केवल 5 ग्राम, रखो अपनी धरती तमाम, हम वही खुशी से ले लेंगे, परिजन पर असी न उठाएंगे." So he very clearly said that we will not go for war if you give even 5. But Duryodhan never agreed for it, and ultimately there was a war. Pandavas may have won it, but ultimately they were not happy with the success in the war itself. History teaches us a simple truth. When mediation is rejected, conflict escalates. The spirit of mediation is perhaps best reflected in the timeless wisdom of Sant Kabir Das, who reminds us that conflict within us survives not because of the strength of the dispute, but because of our unwillingness to look inward. We don't look inward. Atma Deepo Bhav. अपने अंदर जाना है और उसको खोजना है. तो he said, बुरा जो देखन मैं चला, बुरा ना मिलियो कोई, जो दिल खोजा आप ना, मुझसे बुरा ना कोई. So every litigant party has to look inward and find fault with himself rather than with the other party. Then only the mediation can work. Now, long before formal courts exist, communities resolve dispute through dialogue and consent. This is, I'm talking in context with India. The panchayat system functioned not as an adjudicatory authority alone, but as a conciliator forum. The objective was not punishment, but harmony. Modern mediation, therefore, is not a departure from our past. It is a continuation structured within the framework of the rule of law. Now today, mediation finds strong resonance within our constitutional vision of justice also. Article 21 of the Indian Constitution has been interpreted to mean justice that is fair, reasonable, and human. Justice is not confined to correct outcomes alone. A process that prolongs suffering, exhausts resources, or irreparably damages relationship cannot fully satisfy the constitutional promise. Article 39A mandates the state to ensure equal access to justice. This obligation cannot be fulfilled merely by expanding court infrastructure. It requires diversification of dispute resolution mechanisms that are accessible, efficient, and responsive to human realities. The Indian judiciary has over the time recognized the importance of consensual dispute resolution. Judgments such as Salem Advocate Bar Association and FCON's infrastructure laid the foundation by encouraging courts to actively explore mediation in appropriate cases. These decisions reflected a growing judicial awareness that courts cannot and should not adjudicate every dispute. The enactment of Mediation Act 2023, my brother was talking about it, marks a decisive step forward. It provides a statutory framework that institutionalizes mediation, ensures confidentiality, recognizes enforceability of settlements, and promotes professional standards. However, litigation is only an enabling tool. Its success depends on how it is implemented and internalized by legal community. Mediation will assume its rightful place in the justice system not barely by statute but by practice. For a culture of mediation to realize full potential, sustained and coordinated commitment is required not only from the institutions but from the society at large. Mediation cannot succeed if it remains confined to court-annexed process alone. It must be embraced as a first response to conflict rather than a last resort. As a society, we have some obligation. We must rethink our instinctive recourse to litigation. Not every disagreement demands judicial intervention. Matrimonial discord, family disagreements, neighborhood conflicts, and intra-community disputes often escalate not because they are legally complex, but because dialogue breaks down at an early stage. When communication fails, conflict hardens. Mediation restores that communication before positions become irreversible. Courts are designed to decide rights. They are seldom the ideal form to heal emotional wounds or repair fractured relationships. This is where mediation offers an appropriate space, one that is less adversarial, more humane, and oriented towards future coexistence rather than past grievance. To strengthen this approach, there is a need to encourage mediation frameworks beyond the courtroom. Community-based forums, local mediation panels, and social groups can provide safe and accessible spaces for early resolution. Such platforms foster dialogue, build trust, and often prevent disputes from escalating into litigation. Pre-litigation settlements must therefore be understood not as a procedural requirement, but as a collective social responsibility, one that enables communities and families to resolve their differences while preserving the bonds that hold them together. Judges, lawyers, mediators, and court personnel must be trained not only in procedure, but in the philosophy and psychology of dispute resolution. Technology access is human skill, empty patience, and communication that gives mediation its substance. Training programs must therefore integrate ethical values, constitutional purpose, and effective dialogue alongside digital competence. The role of the legal profession is particularly significant in this transformation. Lawyers shape the course of disputes from the very beginning. Their advice determines whether conflict escalates or disescalates. Mediation must not be seen as a retreat from advocacy. My brother was talking about kill the lawyers. That is not true. Mediation will not kill the lawyers. See, the role of the lawyers is to make peace, to get the disputes adjudicated or resolved. So whether we get them resolved through mediation or through court adjudication, in both ways, lawyers would thrive. So it is not killing of the lawyers, but supplementing their advocacy. Mediation must not be seen as a retreat from advocacy. On the contrary, guiding parties towards a fair, timely, and dignified settlement represents one of the highest forms of legal service. Encouraging mediation where appropriate is not a compromise of professional duties. It is its fulfillment. Equally important is the creation of a strong, credible mediation frameworks beyond the courtroom. Panels comprising of retired judges, former senior civil servants, and other respected and trained professionals can play a vital role in pre-litigation and community-based dispute resolution. Such individuals not only may have experience and authority, but also public trust, after making them uniquely positioned as to guide parties towards reasoned and voluntary settlement. Ultimately, mediation thrives when institutions, professionals, and society act in harmony. The goal is a justice system that prioritizes lasting resolution over prolonged conflict, one that resolves the dispute not merely by deciding them, but by healing them. That should be the goal. And as my brother Justice Korean is doing after retirement, he's mediating voluntarily. And this is what I also think, that after retirement, I don't intend to take any assignment, but rather I will do some social service by resorting to dispute resolutions. Either it may be court referred or the parties may voluntarily come. Yes. It would be unrealistic to present mediation as a flawless process. There are shortcomings, there are limitations, but still, to unburden the court, we have to adopt to mediation. Everything cannot be left over to the courts. As we deliberate on mediation today, we are in fact deliberating on the future of justice. See what Mahatma Gandhi used to say. I am reminded, he used to say, an eye for eye leaves the whole world blind. So we cannot adopt that technical approach in adjudicating the disputes. Sometimes law speaks something, but we have to cull out some method to balance the equities and to resolve the dispute finally. So this happens. We cannot go strictly for eye to eye. I am reminded of a film which my father showed me when I was a child. It was on Emperor Jahangir. So the role of the Jahangir probably was played by Sohrab Modi, and the washerman was killed by an arrow from the palace. So his widow was crying, and then one courtesan, he was passing by, he console her and takes her to the palace, and there that heavy bell with a big rope was hanging. She was not interested in going for any dispute, but he provoked her, and takes her. Now he asks her to pull the rope, but she was not able to pull it. It was so heavy, a bell, she could not. He said, put more strength. She could not. Then he helped with one hand, and then the bell could be rung. Now, this was the role which he played as a lawyer. He never used two hands, he used one hand. He helped her to pull the rope to demand justice. And Jahangir appears and he says, I will hear the case, assemble in the court tomorrow morning. The court was there. The entire story was told. The judgment was reserved for some time. Then Emperor Jahangir says, if my wife has killed your husband, now you kill her husband. Now you kill her husband. Now the king has to be killed. The emperor has to be killed. Everyone was in tears. What kind of punishment? So there's no. And then a doctrine of sovereign immunity was evolved. No, king can't be killed. And that lady pardoned the king, pardoned the queen for killing her husband by the arrow. So this is how things evolve. And as a child, when my father explained me all these things, I was taken aback how the law develops. And these are the things, minute things. And even these Bollywood films gives such a good lesson or a message to the children. As we deliberate on mediation today, we are in fact deliberating on the future of justice. We have long been known as officers of the court. Perhaps the time has come to also see ourselves as architects of peace. For the ultimate purpose of law is not merely to decide disputes, but to preserve social harmony. While a judgment brings finality to a case, a genuine resolution achieves much more. It restores fractured relationship, disarms hostility, and heals communities. This is the profound shift we must champion. The Rig Veda embodies the very spirit of resolution. What the Rig Veda says? Move together, speak together, let your minds be in harmony. Move together, speak together, let your minds be in harmony. Let this be our guiding motto. Let mediation move from the margins to the heart of our judicial system. Let us ensure that when a citizen knocks at the doors of justice, they are welcomed not with a sword of contention, but with a shield of equity and a hand of friendship. Let us therefore pledge to make our courts a last resort, not as the first port of call. Let us empower every citizen to resolve their disputes with dignity, accessibility, and lasting fairness. For, as our ethos reminds us, न्याय वही जो सर्व सुलभ हो, न्याय वही जो सर्व सुलभ हो, और समाधान वही जो स्थायी हो. True justice is that which is accessible to all, and true resolution is that which endures. Thank you very much for the patient hearing. It was a privilege hearing, and I thank Skora for giving this platform to us to speak to you, to interact with you. Thank you. Jayati Jayati Mam Bharatam.
Thank you, Your Lordship, for your enriching session. We all have benefited greatly from your valuable insight. Now, as we come to the conclusion of this enlightening session, I take this opportunity to express our sincere gratitude to all our esteemed speakers. May I now request Advocate on Record, Sujita Srivastav, to present a memento to Honorable Justice Pankaj Mittal, Judge, Supreme Court of India. May I request Advocate on Record, Madhurima Sarangi, to present a memento to Honorable Justice H.M. Dilip Nawaz, Judge, Supreme Court of Sri Lanka. May I request Advocate on Record, Sangeeta Bharti ma'am, to present a memento to Honorable Justice Kurian Joseph, former Judge, Supreme Court of India. On behalf of SCORE, I thank you all for attending this session. Thank you. Sir, can we have a photo? Sir, please. Sir, please, sir. Sir, please, sir. Please. Anupam, sir.
Have come and sit in the